Good day everyone, I'm Joevir Limbaga. In this video, I will answer the final examination of CLG 400. Number 1. Define evidence and explain its scope. Revise rules on evidence. Rule 128, Section 1. Evidence defined. Evidence is the means sanctioned by these rules of ascertaining in the judicial proceedings the truth respecting a matter of fact. Revise rules on evidence. Rule 128, Section 2. Scope. The rules of evidence shall be the same in all courts and in all trials and hearings except as otherwise provided by law or these rules. Number 2. What are the three kinds of evidence? Briefly explain each. Rule 130, Section 1. Object as evidence are those addressed to the sense of the court when an object is relevant to the fact and in issue. It may be exhibit to examined or viewed by the court. Rule 130, Section 2. Documentary evidence. Documents as evidence consist of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent or other modes of written expression offered as proof of their contents. Photographs include these pictures, drawings, stored images, X-ray films, motion pictures, or videos. Rule 130, Section 22. Testimony confined to personal knowledge. Witness can testify only to those facts which he or she knows of his or her personal knowledge, that is, which are derived from his or her own perception. Number 3. Distinguish corroborative evidence from cumulative evidence. Corroborative evidence is additional evidence of a different kind and character tending to prove the same point. It is a piece of evidence that may be derived from various sources but proves a common point. Cumulative evidence is additional evidence of the same kind and character tending to prove the same point. This is purely the accumulation of similar evidence that is derived from common sources. Number 4. What is prima facie evidence? Is evidence which, if unexplained or uncontradicted, is sufficient to sustain a judgment in favor of the issue it supports. Otherwise said, if the opposing party does not offer an explanation and present contrary evidence, then the prima facie evidence will be enough basis for the court to rule in favor of the party that offers the prima facie evidence. Number 5. What is dying declaration? Section 37. Dying declaration. The declaration of a dying person made under the consciousness of an impending death may be received in any case where his death is the subject of inquiry as evidence the cause of and surrounding circumstances of such death. 6. What about statement uttered as part the res gestae? Section 44. Part of the res gestae statements made by a person while a starting occurrence is taking place or immediately prior or subsequent thereto under the stress of excitement caused by the occurrence with respect to the circumstances thereof may be given in evidence as part of the res gestae. So also statement accompanying an equivocal act material to this issue and giving it a legal significance may be received as part of the res gestae. Res gestae. Number 7. What is the order of examination of individual witnesses? Briefly define each. So, Rule 132, Section 4. Order in the examination of an individual witnesses. The order in which the individual witnesses may be examined as follows. Rule 132, Section 5. Direct examination is the examination in chief of a witness by the party representing him or her on the facts relevant to the issue. Section 6. Cross-examination. Upon the termination of the direct examination, the witness may be cross-examined by the adverse party on any relevant matter with sufficient fullness and freedom to test his or her accuracy and truthfulness and freedom from interest or bias or the reverse, and to elicit all important facts bearing upon the issue. Section 7. Redirect examination. After the cross-examination of the witness has been concluded, he or she may be re-examined by the party calling him or her to explain or supplement his or her answers given during the cross-examinations. So, Section 8. Recross examination. Upon the conclusion of the redirect examination, The adverse party may cross-examine the witness on matters stated in his or her redirect examination and also on such other matters as may be allowed by the court and in its discretion. Section 9. Recalling witness after the examination of a witness by both sides has been concluded. The witness cannot be recalled without leave of the court. The court will grant or withhold leave in its discretion as the interest of justice may require. Number 8. Briefly explain what is a judicial affidavit. So the judicial affidavit seeks to decongest the ever-increasing caseload in the country brought about the high number of cases filed each day and the lengthy procedures observed. So number 9, an offer of compromise in criminal cases is an implied admission of guilt. What are the two exceptions? There are only two exceptions where compromise is not admissible as an implied admission of guilt in criminal cases. In quasi-offenses or acts defined and penalized under Article 365 of the Revised Penal Code, those allowed by law to be compromised. Their unusual examples are found in the Revised Penal Code, particularly Article 266d of the Revised Penal Code. The compromise that the victim agreed to marry and indeed got married to the accused in a rape case, or if compromise was made before the filing of the criminal complaint. Number 10. In order for evidence to be admissible, it must be relevant and competent. When is evidence relevant? When is evidence competent? So under Rule 128, Section 4, evidence is relevant if it has a relation to the fact and issue as to induce belief its existence or non-existence. From this rule, we gather that there are two components of relevance. First, relevant evidence has a relation to the fact and issue. If there is a relationship between the evidence and the fact in issue, then the evidence is material. So, competence. In addition to relevance, admissible evidence must also be competent under Rule 128, Section 3. Evidence is competent if it is not excluded by the law, or these rules if a piece of evidence is disqualified by the law or the rules of court, then it is not competent and will be inadmissible. Number 11. What is leading question? When is it allowed? Section 10. Leading and misleading questions. A question which suggests to the witness the answer which the examining party desires is a leading question. It is not allowed except A. On cross-examination, B. On preliminary matters, C. When there is difficulty in getting direct and intelligible answers from a witness who is ignorant, a child of tender years, is of feeble mind, or a deaf mute. D. Of an unwilling or hostile witness, or E. Of a witness who is an adverse party of an officer, director, or managing agent of public or private corporation, or of a partnership or association which is an adverse party. 12. What is misleading question? A misleading question is one which assumes as true a fact not yet testified to by the witness or contrary to that which he or she has previously stated. It is not allowed. Number 13. When is circumstantial evidence sufficient to sustain a conviction? Section 4. Circumstantial evidence when sufficient. Circumstantial evidence is sufficient for conviction if A. There is more than one circumstance, B. The fact from which the inferences and derived are proven, and C. The combination of all circumstances is such as to produce a conviction beyond reasonable doubt. So number 14. Distinguish burden of proof from burden evidence. Rule 131, Section 1. Burden of proof and burden of evidence. Burden of proof is the duty of a party to present evidence on the facts in issue necessary to establish his or her claim or defense by the amount of evidence required by law. Burden of evidence is the duty of a party present evidence sufficient to establish or rebut a fact in issue to establish a prima facie case. Burden of evidence may be shifted from one party to the other in the course of the proceedings depending on the exigencies of the case. Number 15. What is the standard of proof necessary in civil cases? Rule 133, Section 1. Preponderance of evidence. How determined in civil cases in the party having the burden of proof must establish his or her case by a preponderance of evidence. 16. Administrative cases. Rule 133, Section 6. Substantial evidence in cases filed before administrative or quasi-judicial bodies. A fact may be deemed established if it's supported by substantial evidence or the amount of irrelevant evidence which is reasonable mind might accept as adequate to justify conclusion. Define what are public documents. Rule 132, Section 19, Classes of documents. For the purpose of their presentation and evidence, documents are either public or private. The written official acts or record of the sovereign authority, official bodies and tribunals, and public officers, whether of the Philippines or of a foreign country. Documents acknowledged before a notary public except last will and testaments. Number 18. So how do you prove and present in court private documents? Rule 132, Section 20, Proof of private documents. Before any private document offered as authentic is received in evidence, its due execution and authenticity must be proved by any of the following. By anyone who saw the document executed or written. B. By evidence of the genuineness of the signature of or handwriting of the maker, or C. By other evidence showing its due execution and authenticity. Any other private document need only be defined as that which it is claimed to be. Number 19. The original document rule states that when presenting a document as evidence, only the original is admissible. What are the four exceptions? Section 3. Original documents must be produced. Exceptions when the subject of inquiry is the contents of a document. No evidence shall be admissible other than the original document itself, except in the following cases. A. When the original has been lost or destroyed or cannot be produced in court without bad faith on the part of the offer. Or B. When the original is in the custody or under the control of the party against whom the evidence is offered and the latter fails to produce it after reasonable notice. C. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established from them is only the general result of the whole. And D. When the original is a public record in the custody of a public officer or is recorded in a public office. Number 20. Who can become a witness? Qualification of witnesses. So, Section 20. Witnesses, their qualifications, except as provided in the next succeeding section. All persons who can perceive and perceiving can make their known perception to others may be witnesses. 21. When is in extrajudicial confession sufficient to sustain a conviction? Section 3. Extrajudicial confession not sufficient ground for conviction. An extrajudicial confession made by an accused shall not be sufficient ground for conviction unless corroborated by evidence of corpus delicti. So that would be all, sir. Thank you.